right, let me start over. Let me call my file 194700023. This is Nielsen versus Nielsen. Ms. Nielsen, if you'd keep your video off, please.
Okay.
That'll help us prioritize the audio, which is the part I actually need. Ms. Nielsen, I'm given to understand that you have released Mr. Neely and no longer wish for him to represent you. Is that correct?
Yes, it is.
Okay. Ms. Hunter, do you have any objection to Mr. Neely withdrawing?
No, Your Honor. Sorry, I realized I was muted.
All right. Thank you, Mr. Neely.
Thank you, Your Honor. Can I be excused then?
Yes, sir.
Thank you.
All right. Ms. Nielsen is present. Mr. Nielsen is present with his attorney, Ms. Hunter. We are here on Mr. Nielsen's motion to enforce judgment. Ms. Nielsen, have you had an opportunity to review the motion to enforce judgment that was filed?
Yes.
It's a pretty simple issue here. It looks like from Mr. Nielsen's motion to his motion and affidavit accompanying that the critical issue is that you have not yet signed the deed transferring ownership of the home so that he can complete the refinance.
I actually did sign it, Your Honor.
Okay, has that been delivered to him?
The title company held on to it. I signed it. I think it was about approximately May 26th or whenever I was asked to sign. In July, approximately the second week of July, when I hired Mr. Neely to represent me, he talked about going to mediation, and we were going to mediate. And so the company informed me that Mr. Nielsen hadn't gone through with his loan, and so they still had the paper. So I had them get rid of it until we went to mediation.
Okay. So you've asked the title company to discard the signed document that you've got, or the signed document that you did?
Yeah, I had them discard it, and so they got rid of it approximately like the second week of July, when I was talking to Mr. Neely, and we were supposed to meet with Mr. Nielsen and go through mediation again.
May I ask what in your mind gives you cause to have your signature, your signed copy of the deed discarded?
Yes. When we settled all that, at that time a year ago, Mr. Nielsen was in contempt. He was supposed to purchase the home from me by January 7th, I think it was, 2020. He did not. So by June, I had hired a realtor to go through the home to sell it. I was under the advisement of my attorney, Scott Waite, at that time. And at that time, me and Mr. Nielsen's mother, Jackie Nielsen, with, I believe, Shani Hunter, they were negotiating with me, and we agreed to settle our entire divorce, the custody, the vehicles, and all the remaining things, and that included the home at that time. And after I signed the partial stipulation, they refused to finalize the divorce, the partial stipulation with the house.
You're talking about the June 30th, 2020
yes.
agreement?
Right. And I had sent Mr. Neely all those documents to provide to the court, and he, I don't believe, submitted them. But I have the emails from Mr. Nielsen's mother that she had been in discussions with Miss Hunter, and we had agreed to settle everything at that time. and
So
that
here's
was the
here's the problem.
only way, like Mr. Nelson wasn't going to.
Ms. Nielsen,
Okay.
here's the problem. So I have, whether you understood this or not,
Okay.
what I have before me is something called a partial stipulation that was submitted June or July of last year, but that was signed and notarized by you on June 30th of last year. And this partial stipulation says the undersigned represent to the court that the following terms are fair and reasonable. The parties stipulate and agree as follows. Real property. The parties reached a partial stipulation regarding real property on October 14th. Home is currently temporary property of father. Father shall buy out mother's equity in the house, with the house having an appraised value of $103,500 and the mortgage payoff being $54,176.50. Mother's equity shall be $24 and change. Father shall have 90 days from entry entry of divorce to remove mother's name from the mortgage. Mother shall sign a quitclaim deed, etc., etc. And then there's a section about distribution of personal property, and then a section about deeds and titles, where the parties agreed to sign transfer title and quitclaim deeds as necessary. And then under the second to last thing it says, partial stipulation, all remaining issues are reserved to the court for further determination. And so coming back to court today and saying, well, we haven't been able to agree on everything else, and so I want to revoke my agreement on the partial stipulation, is not really a valid argument with the court.
Can I just say one thing, please?
Sure.
So I don't know. So when I signed that partial stipulation, it was an agreement to getting the final divorce, finalizing everything within the next month. And I have an email that shows that that's what the agreement was, that we were going to, I signed that with, the intention of signing, agreeing to the custody and finalizing our divorce within the next month. So they had me sign that partial stipulation because we were agreeing to finalize our divorce, and we were supposed to finalize and have the final paperwork signed within the month.
Okay, but what I'm saying to you is, by signing a partial stipulation, you give up your right to retract your agreement on those issues that are included in the partial stipulation.
Okay. And I also did offer, I've offered a couple times, if they would just have the title company write up a new one, I would go down and sign it immediately before today's date. I have asked them several times with no response.
Okay. All right, I'm going to come back to you in just a minute. Ms. Hunter, if I order Ms. Nielsen to comply with the prior stipulation and sign the quitclaim deed so that the refinancing can go through, is that going to resolve at least the emergent issues?
Yes, Your Honor, that will resolve the emergent issue of Mr. Nielsen possibly losing his loan if that does not occur. Also, he would be requesting his attorney's fees, given that we have to get to this stage.
Where practically, how do you want Ms. Nielsen to get that quitclaim deed signed?
I believe the title company has it. My client sent me a copy, which was included as Exhibit 3 with this motion. My understanding is she did go in and previously sign one that she requested that they hold until Mr. Nielsen signed something else, which he had not agreed to. And then she had them shred that at that point. I believe they still do have Exhibit 3, which I filed with the court, which is the deed, and I believe the title company still has that, and that she can go sign that at any time.
Ms. Nielsen, how quickly can you get down to sign the quitclaim deed?
If they're in Delta, we have some flooding. If they're open today, I would be more than happy to do it today. But just like I just want to be clear, I did leave that down there for over a month and a half, so it was signed, and I did what I was supposed to. I just misunderstood that we could take that back to a mediation. So that's, and I've already, as soon as I learned that from my Mr. Neely that wasn't something to do, I offered to go down and re-sign it, and they've never gave me any information like if it was down there. So I would have done that.
And Your Honor, just for clarity's sake, I never received any requests from anybody about signing it after this has been filed. I don't know who she made those requests to, but those never came to me.
All right. Well, we're going to be quick today then. Ms. Nielsen, I'm going to order that by no later than 5 p.m. tomorrow that you appear at the title company and sign the quitclaim deed pursuant to the partial stipulation that the parties previously entered. I'm going to reserve on attorney's fees, noting that we're still pre-decree. If I'm right.
Yes, Your Honor, there's not a final decree. There's still the issues of custody and parent time pending.
Okay, I'm going to reserve on attorney's fees for ultimate judgment on this matter. Okay, can we get that taken care of right away then, Ms. Nielsen?
Yes, Your Honor.
All right. Anything else we need to address today?
Not for me, Your Honor.
Okay. Thank you all very much. We'll see you down the road.
Thank you.